Hi, Ian. Thank you so much for joining me today. I have Ian Machray joining me today from Field Seymour Parks. Ian is a partner at Field Seymour Parks and he heads up the employment and business service team. And he has agreed to have a chat with me today about IR35, but more about employment versus self-employment. So welcome, Ian. Thank you so much for joining me.
No, absolute pleasure. Thanks for having me.
Good. Well, let's get right into it then. Let's start with what everybody's asking me. I get calls and they say, what is IR35? So I think you're probably better placed to answer that than I am.
Well, I'll do my best. So I guess if we take it back to basics, it is legislation that came in April 2000, and it was designed to crack down on a sort of perceived form of tax avoidance involving the use of sort of intermediaries. So in essence, what the revenue was concerned about was that instead of people being employees, they were setting up their own little companies, personal service companies, which they owned and controlled. And then they would send invoices to the client who is receiving the services. The company would get the invoice paid, and then the individual would take the money out of the company through dividends rather than as an employee, and therefore would avoid tax, national insurance. So IR35, various different bits of legislation, but it was introduced to try and ensure that if someone would be an employee, were it not for this sort of company structure, that they get taxed basically as if they were an employee.
Right. Okay. And then this year in April, there was a change to the legislation. Who did that apply to?
Yeah, that's right. So 6th of April this year, the rules changed. It's in the private sector that the rules have changed. So previously, if you go back a little bit, there were similar changes to the public sector, but these changes are for the private sector. And in terms of who it affects, well, it's all to do with the size of the end client. So the business that is receiving the benefit of the services. And they basically need to be a medium or large organization. And in simple terms, they basically need to satisfy 2 of 3 things. So it's either 10.2 million or more revenue, 5.1 million or more of assets, and 50 or more employees. So if you're providing services via your personal service company into one of those organizations and they are of that size, then there is a change. And the change is not, just to be clear, the change is not to the underlying legislation. That still stays the same, but it's about who has responsibility for working out if tax is due. So previously, it sat with the intermediary, so the company that the individual owns and controls. But when it's for a medium or large organization now, the responsibility for tax deductions, etc., sits with the end client, the business that's actually getting the benefit of the services, if that makes sense.
Yeah. Okay, so I mean, I think most of our clients don't actually fall into that category. So, does that mean that they can just continue as normal, continue with contractors as they would?
Well, probably not, or certainly not without any risk. Leaving aside sort of the IR35 changes, there are still risks if you're not labeling relationships correctly. So if you've got someone that you're treated as self-employed, but actually to all intents and purposes, they are an employee, then there could be tax complications, and also they could claim rights as an employee as well. So all of those things that employees can potentially claim protection from.
Okay, and what are the different areas that are looked at to deem whether an individual should be employed or self-employed?
Okay, well, I guess the first thing I should say is that there's slightly different tests depending upon whether you're looking at, are they an employee for tax purposes versus are they an employee for sort of employment protection purposes. They're not necessarily exactly the same. Maybe we'll talk about that a bit later, but that's one thing I should say. But broadly speaking, it's very similar things that either the revenue or the courts or tribunals will look at. And so I'll run you through some of those. One of them is personal service. So an employment relationship is always personal to that individual. You have to turn up and do your job. You can't send your next door neighbor down to do it for you because you want to stay in bed. Whereas a self-employed relationship is normally a sort of business to business type relationship. So it's less common, not always the case, but it's less common that you have that pure personal service requirement. The other aspect of it is this idea of mutuality of obligation, which is a fancy way of saying, for most situations, is about, is work guaranteed and is the individual required to do the work? And again, with an employment relationship, it's normally quite clear. You work 9 to 5, Monday to Friday, and you're expected to turn up. With a self-employed relationship, more classically, it would be, we've got no obligation to give you work, and equally you have no obligation to accept it when we offer it. But if we do offer it and you do accept it, these are the terms on which it's done. So that's another sort of difference. Okay. Another key one I should pick up is this idea of control, which has been in sort of the press a lot lately, sort of the Uber case people have seen. And ultimately, an employer can exercise and does exercise a lot more control over their employees than a self-employed contractor classically. So with an employee, you normally tell them when, where, how they're going to do something. Classically, with someone who's self-employed, there's more flexibility. So maybe around hours, maybe around location, maybe in terms of style or the way they do the work. And those are probably the key things. There's lots of other things. Is there provision of equipment? What do you call them? How integrated into their business are they? Is there any financial risk for them? There's a lot of different factors, but those are probably the main ones.
Yeah. And so those are ones that would have more weight in determining the status then?
Yeah, yeah, that's right. So some of them will have more weight than others. You have to look at the whole picture.
Yeah.
So, for example, if in a relationship you had a sort of an absolute right to provide a substitute under a contract, and that is a right that was regularly exercised, so you could just send somebody else to do the job, and you did that on a regular basis, that probably is enough in itself to prove that someone is self-employed. But most of the factors won't in themselves be conclusive. You just have to look at the whole and work out, does it look like an employment relationship?
Yeah, and I mean, in our clients' scenarios, that's often the substitution part is often not actually exercised because you're running a physio clinic and you've got your self-employed physios and they go off on holiday. You don't want some random person coming in to cover their shift. It usually just doesn't get in. It is usually just not used at all.
It's a big issue, yeah, and people often don't like it. And to be honest, there's normally a lot of shades of grey on these sort of substitution rights. So yeah, at one end of the scale, you have the idea that there's no substitution at all; it has to be you, full stop. And at the other end of the scale, you have this idea that it can be anyone you want. You can just send anyone on. Normally, it's somewhere in between. So you can supply someone, but they have to have certain qualifications. They have to have skills. They have to sign off a confidentiality agreement before they start. Maybe it's subject to approval. And most relationships sit somewhere in that grey zone.
Yeah. Sometimes I'll get some of my clients, if we're talking about whether they should employ their associates or not, they're kind of, one of the very common things that they say is, well, they work at a different clinic as well. So actually, so they are self-employed. How does that sit?
Well, yeah, it's not conclusive in itself. So, because obviously you could have a part-time employee who has two jobs. So what is helpful, I guess, if you want someone to be self-employed, or it's more likely they'll be self-employed, is if they're in business on their own account. So if basically they're running a little business, they're going out there marketing, they've got a website, they're going out actively seeking work, and they happen to work for more than one, maybe for many organizations, then yeah, that does help. But the mere fact that they work for two organizations isn't in itself going to be conclusive.
Yeah. Okay. And and then another kind of statement that's been made to me is, well, actually my contractors have limited companies and they bill the clinic through the limited company, so that should be enough protection. But again, it's not, because they could still be treating them as employees, couldn't they?
They could, yeah. So that's the exact scenario that sort of IR35 potentially kicks in, where you've got that sort of company in the middle. But even if you're not subject to the changes, you still have a risk that if that's not the reality of the relationship, that it could be considered a sham, and in fact there's something else going on, then yeah, there's still an element of risk. It adds an extra layer between the individual and you, but doesn't resolve it entirely, no.
Yeah, I've had quite a few clients say that their accountants strongly advise them against employment. The accountants are kind of saying, it's much more cost effective for them to be self-employed. Don't employ them. Just make sure you've got the right contract in place. So can a good self-employed contract protect the clinic? Like having a service level agreement, would that negate the possibility or the necessity to employ the individual?
No, well, to an extent, I guess is the answer. The reality that the risk with these things and whether someone is going to be found to be employed or self-employed depends upon the reality of the relationship. So if you have a contract that says all lovely things and makes it sound like someone is self-employed, but that doesn't match up with the reality, then that's not going to work for you. So there is no magic contract. But that said, having a well-drafted contract does help, because in drafting that, hopefully you'll have applied your mind to the nature of the relationship, how it actually works. You'd have classified it properly. You'd sort of put in place a sort of the contractual bones for the relationship. So it does help, but it's not a magic solution, sadly.
But yeah, you've got to actually exercise what it says in the contract. Yeah.
That's it. So you could have a clause that says you can provide a substitute whenever you want, but in reality, you're never going to allow that. Well, that's not going to work, I'm afraid.
Yeah. If a clinic owner decided that he or she wanted to employ their self-employed physios, as an example, and one of a contractor decided that they didn't want to be employed and they wanted to remain self-employed, do they have a right to do that? Where does that stand with the clinic? So I've got a client in mind where she wanted to move them onto employed because she treats them as employed generally, and one of the guys was just like, no, I'm not moving.
Yeah, well, I guess the starting point is you can't agree the nature of the relationship if that doesn't reflect what's actually happening. So you can have a situation where you want the individual to be self-employed, they want to be self-employed. Well, that doesn't necessarily work. The revenue may still take a different view on it. And then in terms of someone who's sort of refusing to move on to an employed basis, you've broadly got two sort of options, really. One is that you terminate their self-employed contract, make sure you do that in compliance with whatever it says, but you do that and you then offer them employment. And it's up to them whether or not they take it. The other thing you could think about doing is changing the nature of the relationship so it is one that is genuinely self-employed. But the idea that someone can sort of have their cake and eat it, i.e. being treated as self-employed whilst actually being an employee, that doesn't work, unfortunately.
Good. What would trigger the HMRC to investigate legal adherence?
Lots of things, anything they want, really. It could be a mix of things. The things that we've seen it trigger it in the past are if an employee has made some queries to the revenue that they've sort of led them to believe they need to investigate or question the situation in more detail. Sometimes it can be tipped off. Sometimes people can sort of blow the whistle if they think there's something going on. And they do random checks as well, so you might just be unlucky. The two ones that come up probably most common are where there's other issues with the individual's tax affairs, and that then leads to a wider investigation, or there are other issues with the sort of end client's affairs that then lead to a wider investigation. Are you doing PAYE correctly, etc.
Okay. Yeah, I know of a chiropractor who a number of years ago was investigated for, I think it was around was he declaring all his cash and whatever, and he was squeaky clean on that. And then a month later, they turned up to look at the contracts of the staff. So yeah,
it does happen. Unfortunately, it does happen.
Yeah. Are there any industries that have been specifically targeted? I mean, I know we've seen Uber in the press a lot. Are there, there any other industries that have been kind of looked at in a whole?
Yeah. It does happen. It does happen. So HMRC, on a range of areas, really can sometimes identify areas or sectors where they think there's a particular concern and then target organisations within that. At the minute, I was speaking to some people and there was a suggestion there might be some targeted action in the logistics area, which is obviously quite a hot industry at the moment. Don't know if that's true or not, but there's some rumours, if nothing else, for you. But yeah, it can happen that sectors can sometimes get targeted. Yeah.
Yeah. And what are the repercussions if the HMRC finds that the self-employed associate should actually be employed?
Well, there's probably some unpaid tax that will need to be paid, and then there's the possibility of penalties as well. So there's some specific rules around the change to the IR35 legislation this year, and there's almost like a grace period of 12 months for errors that relate to that. But for sort of tax failures or whatever you want to call it that are separate from that, the penalty broadly depends upon the sort of the underlying reason for why it's happened. So, for example, if it's just a lack of reasonable care, then the penalty is at the lower end of the scale. Whereas if you've got sort of deliberate and concealed sort of tax evasion, then that's much more serious, and you end up being hit with a much greater penalty. So it does depend on whether or not you've innocent or just got it wrong by mistake, or you've kind of known about it and you've ignored it. And they can reduce the penalty if you've helped them get it right. So if you sort of put your hands up and you've cooperated and you sort of sorted things out going forward and paid the dues, it might be less. But it can go back up to 6 years. Right. So there is a risk there, yeah.
Yeah. And is that on the company's responsibility to pay that tax, or the self-employed?
It will depend upon the circumstances and the nature of the relationship. But yeah, it depends a little bit whether there's an intermediary involved, whether it's the individual, the wrongdoing, who's at fault for the failure, I guess, to a certain extent. But yeah, so it's one that has to be determined in each case.
Yeah. Okay. And does it cost a lot more for a company to employ team members instead of having them work as a contractor on a self-employed basis?
Well, there are some extra costs. So if we look at the costs for the sort of the company to employ, so there's employers' national insurance contributions, which are generally 13.8%. There can be a charge for the apprenticeship levy, but that probably won't apply to most of your clients because they'll fall under the threshold for that. And then you have sort of the costs that come with some of the sort of the employment protection, so national minimum wage, but it may well be that the consultants were earning more than that anyway, so that's not an issue. But those are the big things, and then there's little bits around sort of holiday pay. So for full-time employees, at least sort of 28 days, statutory sick pay. But yeah, so those are sort of the extra bits.
Yeah. Okay. And what are the different employment options? So, we've all heard about 0 hours, and it's not really, well, frowned upon, I suppose, 0 hour contracts, but they are there, and they have, I suppose, they have their place. So what are the different options in terms of how you can employ your
no, it's a good point. So it goes, you may remember earlier on I was talking about sort of different tests for tax and employment protections. Well, this is where it differs. So for tax purposes, in simple terms, you're either employed or you're not. And that's it. Whereas when you get into sort of employment protections, there are really sort of 3 different categories. So at one end of the scale, you've got your self-employed consultant, contractor, whatever you want to call them, and they generally don't have any employment protection apart from whatever contract they've got with the company, and that's all they have. And then at the other end of the scale, you have your full-blown employee, which qualifies for all the rights that people are familiar with: unfair dismissal, statutory redundancy payment, the whole lot. But then in the middle, you have this sort of class of worker. and you can have a worker who is not technically an employee for employment protections, and they get a mixed bag of stuff. So they get national minimum wage, they get paid holiday, they get protection from discrimination, but because they're not guaranteed work, this is where your 0 hours contracts come in, they don't get protection from unfair dismissal or statutory redundancy payments, because there's no obligation to give them work. So it's sort of a halfway house between the two, if that makes some sense.
Okay. Yeah. And then what are the minimum statutory requirements for things like sick pay, maternity, paternity?
Yeah, so there's a whole host of things, really, but the big ones, or the big things to think about, is holiday, as touched upon earlier on. So paid holiday for a full-time employee, that will be at least 28 days, including the bank holidays each year. Sick pay is something people often have misconceptions about, but you're only obliged to pay statutory sick pay, and that is £96.35 a week. I had to check that one. But it's not that much, often in comparison to what some people may be earning, and it normally won't kick in until the 4th day of absence either. So sick pay obligations are less. And then often there's concern around maternity leave, family leave, etc. And you're right, people do have those entitlements, but in terms of the pay for it, so for example, maternity pay, yes, that does need to be paid out, but most employers can recover at least 92% of that. So there's disruption, don't get me wrong, but the actual cost of some of it is not actually as great as some people fear.
Yeah, okay, that's great. And then, so I guess, are there advantages of employing people rather than having them work as a contractor? What do you see the advantages as?
A lot of it's to do with control. So if you've got an employee, you can be very clear with them in terms of what is expected, how they do it, when they've got to turn up, the fact they've got to do the work, they've got to do your work ahead of anybody else's. It's you can impose without concern about tax issues, sort of post-termination restrictions on them, so what they do afterwards. And you can present it, it's joined up, it's clean. You don't have to worry about making sure someone is seen as a contractor rather than an employee. You don't need to worry about substitution clauses and all these things that people don't like in their contracts. You generally don't have to worry about any of those things because they're an employee, so you don't have to sort of dance around the edges a bit. So that's really the key advantage.
Clients often resist employment because they believe that it's really difficult to get rid of employees. And I think it's quite amusing in a way, because I can see that a lot of my clients struggle to get rid of contractors because they're just too scared of having the conversation. But how difficult is it to terminate an employee's contract?
What you first need is a good employment lawyer. If I find any of them, I'll let you know. I'll let you know. But no, it does differ. Obviously, you can have the same practical issues you have with a contract. You're going to have the discussions and bite the bullet. But the biggest protection, or the biggest concern for most people in employment law, is unfair dismissal. And that basically says that if you're going to dismiss someone, you have to have a fair reason and follow a fair process. But that, generally speaking, doesn't kick in until they've been with you for 2 years. So you've got quite a long grace period. And you need to be careful you're not discriminating and none of the other protected claims arise. But it's not quite as difficult as some people might think. And also, equally, even after the 2 years, you can still do it. You just have to be careful about how you go about it.
Just follow the right process and go through. And just, as you say, get support. Get a professional involved so that they can help you with that. But generally, within 2 years, you should know if this person is fitting your company. Well, within 3 to 6 months, I would say you should know that.
You'd hope, wouldn't you? Really?
You'd hope, I know things can change down the line, but generally speaking, you know if you've got the right person on board. And so is there a difference in, I think you did briefly touch on this, that is there a difference in enforcing a clause that prevents someone from setting up down the road, comparing an employee to a contractor?
So you can do it with both. The concern you always have when you're doing it with someone who's self-employed is, it goes back to this control idea. So the more you are preventing them doing things, the more it starts to look like an employed relationship. And so the advantage you have with it, I guess, in a employment contract is, yes, they still need to be reasonable and to make sure they're enforceable. But you don't have the worry that you're going to sort of risk the tax status that you think you've got by imposing restrictions. And that's particularly important when you get into things like a sort of a classic non-compete, i.e. you're not going to set up in competition. It's quite difficult to do in a self-employed agreement. It's more common that you'd have something that focuses on the clients that they've been dealing with, and prevents that aspect of it. But in an employment contract, it is possible, or indeed easier to a certain extent, to have those sort of non-competes in there.
And so having them in the contract is one thing, but I suppose being able to enforce it, do you have the difficulties in both scenarios in terms of, how enforceable is it to say, if you leave this practice, you can't set up within 5 miles of the practice for 2 years? How easy is that? How often is that actually upheld?
Essentially it's the same process, regardless of whether it's someone who's employed or self-employed in terms of enforcing it. So it's still high court litigation generally to enforce them. So there's a lot of challenges with enforcing them. I think it's fair to say, and potentially they can be quite costly. The one advantage you might have from an employment perspective is that they have been integrated into your business. They probably will have had maybe more access to confidential information, to clients, etc. That might make it easier for you to say, well, they've had access to all this stuff, and therefore I really need this non-compete, this clause preventing them from soliciting clients. Whereas with someone who's only working with you some of the time, they're doing it on a sort of business-to-business arm's length arrangement, it's more difficult to say that type of clause is appropriate.
Yeah. Okay. And who would the patients belong to, if the clinicians are self-employed and contractors? So they're contracting to a clinic, and the clinic is providing them with the patients, and they're treating those patients. The clinic is administering those patients, but the contractor self-employed. Who do those patients actually belong to?
Well, if you've got someone who's employed, they will definitely belong to the employer. Because that's just the way it works. If someone's self-employed, then you'd need to be very clear in the contract, because there is a risk that you end up with a dispute around who those clients belong to, in terms of personal data relating to them, ability to work with them in future. So you can specify and control who looks after. Obviously they can still go to someone else entirely, but who sort of controls that relationship. But you have to be a bit more careful on the self-employed side.
Right. Okay. And how often should one review contracts, whether they're employed or self-employed? What's the kind of recommended advice for that?
I'd say at least annually. I think that so I'd look at your contracts annually would be a sensible point, and it may well be you don't have to do anything to them, but it's still a good time to dust them down and check. In terms of what I would say is, in terms of the status, particularly say if you've got self-employed people and they're reasonably sort of long-standing, so not sort of short project based, then I would say, aside from the contract, you probably want to review the nature of that relationship more often. So maybe every 6 months you need to look at it, because what classically happens, it will start as a self-employed relationship and they'll be going really well and they're important to the business, and all of a sudden we're going to give them some management responsibilities, and all of a sudden they're not self-employed anymore, and that's why you just need to look at it every so often. Yeah,
great. Ian, you've helped a number of our clients already transition from self-employed contractors to employed. how can our audience get in touch with you?
Well, yeah, we'll be very happy to sort of help anyone. And equally, if on the other flip side, I guess, if people are looking to help ensure that their self-employed relationships are self-employed and the contracts reflect that, we can do that as well. But you certainly on our website, which is www.fsp-law.com. You can find all of my details on there. Alternatively, you can get me on my probably mobile's best at the moment. There's a bit of hybrid working, so that's 07919 328 122. An email address and everything's on the website as well. There's also some other resources on there, some webinars, pre-recorded webinars on IR35 as well, which some people might find useful as well. But yeah, it's all on there.
Yeah. Brilliant. Ian, thank you so much. I'm sure that everybody listening is going to really enjoy this interview, and kind of be in a good position to look at their situation, and hopefully also just feel less fearful about going from self-employed to employed. So I really appreciate your time. Thank you so much. And I'm sure we'll talk again.
I'm sure we will. No, that was great. Thank you.